Good morning, friends. Before I start my address, I'm here because the students who had come for internship at Lucknow hugely impressed me. So I wanted to meet all of you, expecting a very good bunch of students over here, and also to congratulate the faculty here for putting in the excellent work. So here I am. I'll try to simplify the topic, explain it to you in a simpler language so that you can appreciate it. It is not going to be a very academic thing. I try to put it in very simple words so all of you, even those who are not from the field of law, would understand it. Now, before I start it, there is a principle that I follow, and that's a principle I believe every student of law should follow. I follow a principle that it is the duty of a court, and I would say it is the duty of every person involved with law or with this institution, is to settle law which is not yet settled. That's okay. What is not settled is to be settled. To revisit law which is already settled. Now, why do you revisit law what is already settled? It is for two purposes: to affirm which is rightly settled, to modify which is wrongly settled, and then to make corrections with the change of time which needs to be corrected. Because law is an always evolving process. So whenever you study law, don't read it or don't understand it as if it is something casted in iron and it is there forever and ever. Now this theory or this principle of law that we are going to discuss on this doctrine is one such thing. It is something which is evolving since our independence. It did not start in 72 or 73. It was there in discussion for 25 years prior to that also. It is in discussion today, and it would be evolving itself when you people would be there handling this institution, and it would be evolving when the next generation would be there. This is nothing which is casted forever. Now, what is the conflict and why it is there? So the conflict is between two articles of the Constitution. There is an Article 13, which comes just before the fundamental rights in Part 3 of the Constitution. It simply says, it's very simple worded, and it simply says, all laws in force in the territory of India immediately before the commencement of the Constitution, insofar they are inconsistent with the provisions of this part, shall, to the extent of such inconsistency, be void. So all earlier laws which are in violation of fundamental rights are void. The state shall not make any law which takes away or abridges the rights conferred by this part, and any law made in contravention of this clause shall, to the extent of contravention, be void. And the state will, in future, also not make any law which is in violation of fundamental rights. So, fundamental rights were protected by Article 13 to the extent that earlier laws which are violating them will not stand, and the future laws in violation of the fundamental rights would not come. Now comes Article 368, which is power of Parliament to amend the Constitution and provides a procedure for the same. This is also very simply worded, and again a very widely worded article. It says notwithstanding anything in this Constitution. So in a way it takes away Article 13. Notwithstanding even the Article 13, notwithstanding anything in the Constitution, Parliament may, in exercise of its constituent powers, amend by way of addition, variation, or repeal any provision of this Constitution in accordance with the procedure laid down in the Constitution. So 2/3 of the majority present in voting should be more than half of the majority. Again, in clause 3 it says, nothing in Article 13 shall apply to any amendment made under this article. So it further specified, not merely with notwithstanding, that Article 13 will not come in way of the power of Parliament to amend. So far so good. So 13 can also be taken away. 13 will not come into way. The fundamental rights can be taken away. Now starts the journey. The very first amendment to the Constitution came, and it was challenged in Shankari Prasad Singh Deo versus Union of India, 1951. The question was whether amendment to the Constitution is a law, and if it is a law, whether it is hit by Article 13 or its validity can be checked in Article 13. The then Supreme Court judges went with the literal interpretation. They said no, constitutional amendment is a different thing. It cannot be checked by Article 13 or the fundamental rights. 65 again, this question came, Sajjan Singh versus State of Rajasthan. Supreme Court again said, now it started diluting. 65 it was with a majority of 3:2. And they again said, no, we'll go with the literal interpretation, you can't do it. Justice Hidayatullah wrote a very interesting judgment, dissenting with the opinion of the majority, and he said if fundamental rights are fundamental, actually they are fundamental, or it is only a name given fundamental, since they can be taken away as any other right. So what is the meaning of this word fundamental right? If Parliament can, by a simple amendment in the Constitution, take the same away from the citizens. So from there, different thought lines started coming. Next was Golaknath versus State of Punjab, 67, within 2 years again. Now, this time instead of a 5 judges bench, it came up before a 11 judges bench. And the 11 judges overruled all the earlier decisions. And they said, amendment can only be subject to the fundamental rights. So fundamental rights would prevail. For the first time, a different interpretation or a reverse interpretation was given, and they said no, 13 will prevail even over the constitutional amendments, and the fundamental rights will prevail. Now, they gave a judgment, but a different situation arose. So that means even the fundamental rights cannot be amended. So that means the Constitution or the fundamental rights stood frozen to the status it was in 1965. There cannot be any change. So we can't evolve even new fundamental rights. So even that was not treated to be a good judgment. And then matter was referred to still a larger bench, Keshwanand Bharti, largest ever bench sat in Supreme Court, 13 judges. That modified and came up with a principle of basic structure. That is also with a majority of 7-6. So, Golaknath is with a majority of 6:5. Keshwanand is with a majority of 7:6. So only one judge was having a better view, and therefore this law prevailed. Now, what is the basic structure? Basic structure theory is very simple. It says that there is a basic structure of the Constitution which includes fundamental rights, and Parliament is having all powers to amend the Constitution but to disturb the basic structure. This judgment did not say at all what the basic structure is, and till date none of the Supreme Court judgment has laid down what that basic structure is. They have said it is there. What it is, they have left from being specifically worded. So it has been left to the wisdom of generations to come to understand, interpret and implement. This is a very novice thing, or this is a very, when we discuss it further, this is a very necessary part of it, that most of the important principles are left at a level that they can be revisited as per the requirement. So never believe law is a straight jacket principles which one has to just copy and paste or put the facts into the said framework and then say, in this fact, this framework will apply. There is no framework with the principles of law. And the framework changes its structure as per the circumstances, as per the need of the society, as per the need of the movement. It could be temporary. So that is what is left out when this judgment. Now there are arguments in favor of the basic structures theory and there are arguments against the basic structure theory. The arguments in favor of the basic structure theory broadly are: it limits and checks the legislature from uprooting the resolve of the freedom fighter or the constitution framers, and it gives an absolutely new interpretation to the constitution. So the constitution framers laid down a formula or the principle of interpreting the constitution or the manner of working of the constitution. They specified the power of the constitution makers, parliament, and the power of the judiciary, and they laid down specifically how much is the scope of Article 13 or fundamental rights and the power of the parliament to amend the same. And now judiciary is trying to change that situation. So this judiciary can do or not, or should do or not. It protects people against threat of autocracy of majority, be it on religion, linguistic, ethnic, political, religious, economic, capital, so many principles. So once you have a basic structure theory, it restrains the parliament to amend the laws or take away the fundamental rights or impact the fundamental rights or impact the constitutional framework merely because it is having a majority. Now this lies in the history of the country. That is why there is a need to study the history. Most important subject is history to be read with the law. Unless you go through the history or the modern history of the country, it would be difficult to understand the growth of law. So there were circumstances, there were many wars between 50 to 72. There were some circumstances where emergency powers were invoked. With those emergency powers, the fundamental rights were attempted to be curtailed. So that is from where this principle was evolving slowly. That whether the government, merely because of its majority, and there was a one-party rule continuously from 50 to 75, rather 77. So having an absolute majority in the parliament. So whether one party having an absolute majority in the parliament can simply by amending the constitution take away fundamental rights. The next question definitely is whether one party having an absolute majority in the parliament can tomorrow say there will not be a democracy but a dictatorship. Or a dictatorship type democracy as our neighbors are having, who don't have a strong judiciary. Or a one-party democracy, calling it one-party rule, absolute dictatorship, calling it a democracy with another neighbor. China is having a one-party democracy. I don't know what one-party democracy is. And there is no opposition, what is the democracy about? So those experiences were coming up. So whether it can be done, it has to be checked, therefore judiciary was taking up. Most of the principles behind fundamental rights form a part of basic structure. So it was in a way to ensure the fundamental rights such as right to life, equality, freedom to practice religion, protection against arbitrariness, rule of law, etc., not to be taken away. So when we read our fundamental rights, please don't cram them. Don't say this is a fundamental right. No, it's never like that. Every fundamental right has a principle or a reason behind it. So you say there is a right of equality. I'll just give you an example on equality. So there is a right of equality. Now from where? Why? Why should there be equality? The equality is there because there is a democracy. how is the democracy impacting equality? So what was before democracy? Before democracy was a king's system. There is a king. एक राजा है, उसके पास सारे अधिकार हैं और उस राजा को यह अधिकार है कि वो जिसको जो चाहे दे सकता है, बेनिफिट्स जिसका जो चाहे कर सकता है. This is arbitrary. If he starts giving benefits to the people of his culture or to the people of his religion or to his family or to his friend or absolutely on his liking or disliking. Today I like you, I give you an entire state, power to rule over people. Tomorrow I don't like you, I throw you off from the top of Lal Killa. And if you don't die, I'll pick you up again and take you there and throw you again till you die. If that is the power of a king, then same power is left in one institution in a democracy, and it is not okay. So when we bring democracy, when we say it is of the people, for the people, by the people, then it must be equally for the people. One. Second, unless the government ensures to give back exactly the same for each vote that is casted, it will be able to buy votes. If today the government is able to decide or say that we will give all the majority population in a state, it can be ethnic majority also. In different state, it can be different religious majorities. So we will give all the majority population 50,000 rupees per month and not give it to the majority population. They'll never go out of power. They'll remain in power because they'll get majority of votes. And minority will become poorer, left out in the society. So the government is not giving equal in return of the vote. So when they take a vote, they have to give equal to everyone. There is a parity. The principle of equality is necessary for democracy to survive. The moment principle of equality is taken away, the very principle of democracy will be gone. So that is why there is a principle of equality. So Article 14 is basically giving a framework to that principle of equality. But the principle of equality is not coming out of Article 14. It has very strong reasons behind it from where it comes out. So when you interpret Article 14, you don't just read the language. You also understand the philosophy and the principles behind it and what it is trying to say. Now, unlike Gorakhnath's judgment, basic structure doctrine does not freeze fundamental rights in time. That was a negative, very strong negative with Gorakhnath. It allows Parliament to extend new fundamental rights, or the Supreme Court or the constitutional courts to read out new fundamental rights as per the change in the society, or as per the needs of the society, or as per the growth of the society. So you came out with internet and social media and everything, and right to privacy, which was very normal with everyone because nobody was able to intrude in privacy of other persons till the social media came in this manner, till the society developed in this manner, was not required to be read to that extent. There was a privacy recognized with everyone, but there was a limit to it. Now with everything, every information available on net, right to privacy was required, that how much other person can intrude in other person's life. This is a very interesting law, bill, which probably, to my understanding, is the only bill which was sent to the President of India and never came back from there. So an amendment was brought in the Telegraph Act, Post and Telegraph Act, with the majority government of that time, it was Rajiv Gandhi's majority government, that any mail can be opened by the government and read, which is going through its post offices, which was the only mode of communication at the time. And if there is any offensive material in that, then appropriate legal proceedings can be taken. This was passed by the parliament. It was sent to the president. The president was Gyani Jal Singh, and he never returned it back. And nobody thereafter asked for it. Probably the only incidence, the parliament even didn't ask for it. हमने आपको कागज भेजे थे, उसका क्या हुआ? Can you believe such act in today's world? At least some politicians thought it at that time, some government thought it at that time, and even passed a bill from the parliament, got it passed. So, can it be permitted? So, we read a new fundamental right and right of privacy. And that much is what this new basic structure principle permits. Then in a democratic republic, different democratic institutions are established and strengthened to keep a check and balance on exercise of state power. This doctrine is also embodied and strengthened by the principles of this new theory of now this I will explain more in my conclusion and the questions that you will be putting to me. I hope you will be putting you. I expect you to be bright enough to put up some interesting questions. I'm waiting for some interesting challenges from you. It also allows the parliament to enter or exercise its sovereign powers, one of them being, for example, power to exchange territories. So India exchanged territories, some certain territories with Bangladesh recently. So it gives it that much power, but it does not give it absolute power to surrender territories merely on its whims. So there is a basic structure that you have to maintain the sovereignty and integrity of the country. Integrity includes integrity of the territories also. So a government can, a parliament just simply say, okay, we are giving away certain land to certain country because we want to. So the courts can look into the reasons and keep a check on the same. This is just one field. There can be thousands of different fields where concessions can be given by the government. Broadly, these are policy decisions. The courts do not interfere with them. But where it goes beyond a limit of reasonableness, then definitely the courts can look into it. So the basic principle keeps constitution in a synchronized manner. It gives a certainty and continuity, and therefore with certainty and continuity comes the belief in a system. To really be able to work in a system, one should be sure, yes, this system is going to be there. If you have a college where there are no fixed time of class, so a teacher can at any time call a class, then it would be very difficult for students to go with the same. That system would face so many difficulties. Or if, suppose, every day the teaching system in the institution is changed, so it would be very difficult to understand it and to regularize your life or regularize your work according to the system. So the same goes for the country. The country needs to have a broad basic structure, a basic system, so that people will know, yes, this is a democracy which is going to be there forever. There is going to be a voting system. This is the type of voting system they have, because democracies are also different. There is a different American democracy, there is a different Canadian democracy, there is a different English democracy, there is a different Indian democracy. So India is having this type of democracy, it is going to be there. There people have certain rights, they are going to be there. There are certain foreigners also have certain rights, they are going to be there. This is going to be its basic structure or the manner of working. And this is a stable system. This is not going to change overnight. Somebody will come, change overnight, or a majority government will just say overnight, okay, yesterday we were secular, today we are not secular. Or yesterday we were democracy of this type, today we are not. Or yesterday we were socialist. We were working for the benefit of people, today we are capitalist. Or we are communist. So everyone, people of this country, as well as foreigners who interact with our country, they need a belief that this system is going to be there, we can have a long-term relationship with this system. So for that, a basic structure is necessary to be there. But there is an equally strong criticism of this system. First and foremost, and very simply put, it is a judicial overreach. Judiciary has no reason to read constitution in a different manner than it is written. So it is going beyond what our constitutional assembly said. It is going beyond what the parliament has continuously kept in the constitution for last 75 years, or at that time for last 25 years, and it is reading something contrary to what is written in the constitution. That is the first criticism. You cannot read something else than what is written in it. Now the question would be, why? I'll try to answer that in my concluding portion, or whether it should be done or not. This theory is not correcting everything that is wrong with the constitution or interpretation of constitution or running of the society, merely by making a basic structure which is not yet explained. It will not improve anything. And one of the simple example given is that you bought this principle in 72, emergency came in 75, and the courts did not do anything when all the fundamental rights were taken away. Well, that is one of the worst phases of our institution, judicial institution. There can be no explanation except to admit, yes, it was one big folly that Supreme Court did at that time. And the Supreme Court has also reversed those judgments now. They have also accepted that there was wrong law put in. And the wrong law put in was, your generation was not there. It was put in, I just put it in a very simple word. So there came up a visa law, Maintenance of Internal Security Act. Just to put it in a very simple words. So if your name is Ram Singh and police comes to sue you and they say, no, you're not Ram Singh, you are Shyam Singh, and we are arresting you because there are cases against Shyam Singh. You cannot even file a habeas corpus saying, I am not Shyam Singh, I am Ram Singh, please leave me. SDM Jabalpur was a case in which MP High Court said, no, habeas corpus is maintainable, you can't do like this. And Supreme Court said, no, MP High Court is wrong. This power is there in this act and we are holding it. This came after the basic structure, after we said that we will hold stronger fundamental rights. So, when you could not do it in 75, therefore it is not good. This is the second criticism. Then they say this creates very unnecessary litigation because every time there is a constitution amendment, the first challenge is on the ground that it is against the basic structure. Because nobody knows what the basic structure is. So every time there is an argument, this is against the basic structure, so it is giving unnecessary litigation, which courts also find at times unnecessary, that this is not applicable to this amendment in constitution, but it is creating this unnecessary litigation. It also says that it is coming in way of necessary reforms in the constitution because the government is apprehensive that every time it goes for a reform, there would be a challenge. It is against the basic structure. So the government says, or those who support this view again says, that no, since the government would be unable to understand basic structure, so it will not be able to amend the constitution in the right way, and therefore it is coming in way. Fine. It allows judges too much of powers that they have started reading or interpreting constitution as per their own philosophy of basic structure. Along with this also comes an argument that 400 people, more than 400 people sitting in parliament are not able to understand what the basic structure is, but 5 judges sitting in Supreme Court are able to understand the wisdom of 5 judges over such a huge number of people. How do you explain that? That too, people who are not elected but are selected. Or judges are not elected. The elected people are in the parliament. That is another negative which is said about this principle. It also says that this is not in trend with the society, or to say it is not in trend with the, or it is in conflict with other principles settled by the Supreme Court. One of them being that we have a living constitution. It is developing, growing with the changes in the society or with the growth of the nation. If you say that there is a fixed basic structure and there is a need to change that basic structure or some of the part of that basic structure with the growth of the society, then how do you do that? So you have frozen part of the constitution in time, putting a restriction that it cannot be changed. The parliament cannot change it. At the same time, keeping a power into yourself that anytime you can say, no, this is not part of the basic structure, this can be changed. And we sitting in Supreme Court can change it. Because last two fundamental rights were read in Supreme Court. First they came in Supreme Court, then they came in Parliament. It ensures, or rather the criticism is that it is a backdoor exercise to take away power by the judiciary from the democratically elected government. That is a simple. You are trying to take away a power which exclusively vests and rests in the elected government. So you are taking away what is the power of people of the country, because those people have elected. So you are working against the principle of democracy and taking away what is not provided in a democracy, that is expression of people through parliament. This is another criticism which is coming up. Or to put it in other words, it plays fraud on the intention of the framers. Framers of the constitution did not intend this. You have absolutely violated the language, read something contrary to what is written. Then they say it is full of contradictions. When you don't know what the basic structure is. So one bench would say this is the basic structure, other bench would say this is the basic structure, and there would be conflicting views. Every 3 or 5 judges sitting in Supreme Court having a different view would create so much of contradiction. This has to be rested with the parliament, which can actually say what is our basic structure. This cannot be taken away by the judiciary. The principles are too vague. This says that even the Supreme Court doesn't know. In SR Mumbai, 1994, Supreme Court said federalism is part of basic structure. We have a federal country. Government came up with GST. They say we have a federal system, but in federal system we can have portions which are not federal, where the tax would be collected jointly and then distributed, and all the states can sit together and decide it. In a federal system, each state has its right. There is no collective right, and then center has a right. They say no, we can do away with that. And actually the parliament has done away with that. And Supreme Court has put its stamp on it. So even with the basic structure theory, there is no certainty about the basic structure itself. So when you permit parliament to make a constitutional amendment which is directly against the basic structure already declared by the Supreme Court, and then it is affirmed by the Supreme Court itself, then it creates a conflicting situation, and then nobody is able to understand what basic structure is and to what extent government can do. Then it creates another situation that whether there can be a retrospective amendment of constitution. So what you call a basic structure, can we go back in time and amend it from 1950 and then it will not be a basic structure? Because the parliament says we can do it. We'll go back in time, make a retrospective act, effective from the date the constitution was adopted, and then say it was never part of the constitution, it cannot be read into it. So can we do it? And there is no judgment on it as yet. Retrospective to what date? What can be the cutoff? It will be 72, or it will be 1950, or it would be some later date. Then it says that definitely what we have already touched, that it undermines the popular will. So it is going against the popular will. So these are the basic pros or the arguments in favor and against the basic structure. So far so good. So like a good judge, I am not going to open my views what they are, because a judge is not expected to have a preconceived notions. He should be open to arguments and can only express his views through a judgment. So one way is I conclude while taking your questions, and one way is I conclude and then take up your questions. How would you like it? So if there are questions, then we'll go with the questions and then I'll express my whatever broadly views.
So forum are open for questions. Be bold as you can, but be concise. Yes. Sure.
Okay, before you start any questions, anyone wants to ask a question who's unable to understand this concept or any part of this concept? So if there's any question that yes, there is some part of this concept you have not been able to, or I have not been able, a good enough person to explain it, you can put it so that I can clear it, and then we'll go for the really intriguing questions. So, yes.
So you mentioned that each fundamental right has its own reason and subsequently gave an example of the right to equality, right? Then sir, what is the need of that article protecting that specific right which cannot lead to the improvement of the situation in our society? And then what is as our topic, the question says, shouldn't we revisit this basic structure doctrine of our Indian Constitution?
Should we not?
Shouldn't we revisit the basic structure doctrine of our Indian Constitution or not?
Any other question similar to it? दे दीजिए, let him ask. Let him the first person also ask.
Morning, sir.
Yes.
Good morning, sir. So I have a question with regards to basic structure only. That if Parliament, there was a debate going on that Parliament tries to define basic structure. That if Parliament tries to define it, is it the right way? Like, should the Parliament define it, and should we allow it? Should we allow it in our throughout the judiciary? And like, as the Parliament is the face of changing society, so therefore my basic question is, should we allow this to happen, and what recourse should Supreme Court take if the Parliament does so? Thank you.
Yes, what's your question? He's been dying to ask a question. Please.
Sir, we have seen in Indira Gandhi's government, the emergency was there. So, sir, many people were falsely convicted, and sir, their rights were being denied. Sir, what if similar stands occur in future? Sir, is our basic structure doctrine ready to ensure people's their right during emergency?
Good question. Okay, so primarily the question is that why Parliament, when it has power to do and it is written there, why we should not leave the basic structure also to the Parliament itself or the government itself, and how judiciary would react if a 75 emergency situation arises again. So let's go out of law for some time now and interpretation. So what is democracy? As we were talking, democracy is of the people, for the people, by the people, with regard to what? Rights of people. What is this? Of the people, for the people, by the people. For what? What are we talking about? Rule. The second system is which we all follow is a rule of law. These are the two primary things. Now, what would happen if we take away the power of a king and vest it absolutely in a parliament or in the government? So the government or the parliament will become king. Now, how's a parliament working? Our parliament works on a party system. So any party in majority would form the government. So any party in majority would be in a position to bring in a constitution amendment. So it can change the basic structure also. So it can take away your fundamental rights also. Because power to amend the constitution will prevail over section 13. So you will be left with no fundamental rights. So emergency situation, 75 situation will again arise. Can arise. Might arise. So how do the democracies check it? You must have heard so many times that there should be democratic institutions. So to check that absolute concentration of absolute power at one place, it's need of democracy to develop different strong democratic institutions. Our constitution is broadly reading three of them. One is parliament, one is executive, legislature, executive and judiciary. So these are three pillars on which democracy rests. Now the head of the legislature is the government, head of the executive is the prime minister. So two of the pillars are having a common head, and third is the judiciary. Now if one person or one body or one party starts control all three of them, then is it not a king's system or old ruler system in a new shape? Then how it is a democracy? Where then power of people is again concentrated in one person or one party or one place? Then who's going to check exercise of that power or arbitrary exercise of that power? So you should have different, or at least three, parliament says there should be three separate democratic institution, primary democratic institution, and then we try to, with experience in the democracy, we try to create some more. Election Commission is one of them. So Election Commission is given independent power from the government, absolutely segregated from the government or control of the government, so that a fair election can be held. If the party in power makes such law or exercises its executive power through the executive, that it is able to manage the elections, then it will never go out. So how would the power of people be exercised? It will no more be for the people, of the people, by the people. It will not be of the people. So there is a need in a constitution to have check and balance. Only then the democracy will survive. So there is the very first word, democratic, needs check and balance. The power which the people are vesting in the government should be in different organs of the government which are separate from each other. That is why you find so many judgments of Supreme Court or High Courts which says that the secretary concerned who's exercising the executive power is bound by direction of minister only as which are given as per the law. If the minister is giving some illegal directions and he is following them, then he is equally liable for the action that he has taken. He has to stand up and say, no, I will not do it. The judiciary is trying to make the another institution, constitutional institution, democratic institution, that is executive, strong enough to say no to the other institution, which is a political institution, which comes through winning votes in parliament, which is the government. which can check the work of the government. It is not just the job of the judiciary to do it. It is the job of the executive also. So therefore, there is a need to make a strong judiciary which can come up with theories necessary to check the power of the state, which would be denying the democracy or the democratic law, which would be impacting the basic structure of the constitution. Because with the basic structure of the constitution, directly involved are the rights of the public of this country who have chosen the government. So we cannot permit anyone to once come in power and then say, fine, for me there was a democracy, but for future there will not be a democracy. And who can challenge it? The courts. How can they challenge it? Only by putting restrictions upon the power of the parliament to what extent it can change. But that is only one part of it. So there has to be some stronger, more relevant, more specific laws which will come with time. There's not one concept that a principle of law or a policy declared by law or a judgment of law is cast iron. It has come and now it is frozen in time. No. This theory particularly, this is the most flowing, most lucid theory which has ever come. The Supreme Court itself is saying we are not putting any framework to it. The Parliament is also aware what are the four corners within which the Constitution can be amended. We are only keeping an eye whether what you do is within the four corners or not. You change the federal system, we understood it is the need of time. We understood the entire country is with this idea, we permitted you. Doesn't mean that federal system is gone forever. In one particular circumstance, it was required, we did it. Maybe in another circumstance you will come, we are reaching with the federal system, you will say no you can't. So it has to go from incidence to incidence, from case to case, from facts to facts, as and when they come. So every time it has to be revisited. So to say why this should not be revisited, it will be revisited every time. And
Sir, in 2014, Supreme Court said that this NJAC amendment is unconstitutional. Sir, my question is that there is a constant diversity deficit going on due to the collegiate system. Don't you think that there should be more transparency and the NJAC is a way to ensure transparency in the system? And you sir also talk about the check and balance. So there is a dominance of the judiciary when it comes to the appointment of judges. So don't you think that we need adequate representation of the executive to ensure that the SCS and minority communities are getting representation in the High Court, Supreme Court? And sir, for example, that how many of your colleagues in Lucknow High Court are from the STSC community? So there is a constant diversity deficit going on.
I'll answer that. No, absolutely. You can have another seminar on the question that you have asked. I have done one in Hon'ble College, Hon'ble University at Lucknow, precisely this issue. So I have no issue. It's very simple.
Yes.
Don't worry.
Good morning, sir. My name is Anushka Kudesha. I had a question that isn't the doctrine creating an imbalance between the responsibilities of the Parliament and the Supreme Court for protecting the seamless web of the Indian Constitution?
All right.
Yes.
Good morning.
Let me first answer the first question because that in itself is a absolute conference in itself. Okay. So why judiciary should have its own selection of judges and have a power, not why executive should not have a say. So what is the, it will take me 5 minutes, so bear with me. So what is the system or what is the procedure in which the judges are selected? I'll just explain it and then answer will confirm that. So there is a collegium. The top 3 judges are to find out the names. Chief Justice and next 2 judges in a High Court find out the names who are the good person who can be eliminated. They take input from the judges in Supreme Court who are from that High Court, who have worked in that High Court. Like Justice Chanchul was the Chief Justice of Allahabad. So when the collegium will hold a meeting here, they will also take input from him in your time, or who were good judges who could not be elevated at that time, or who were younger in time, or whatever. They take input from judges. Justice Vikram Nath is there, so many other judges. Justice Bindal has just gone from Punjab. Then they will ask the senior judges or whomsoever they feel like, the judges of the High Court, give us some good names. They also interact with lawyers, give us some good names. The Advocate General gives his names, which are treated to be names given by the government court. As simple as that. Because he is speaking for the government, so the government has a say that these are also good people, take them into consideration. Okay, so the collegium will sit, find out how many vacancies we have to fill up, how many of them are good, how many should be sent in this one, what is the proper representation in them of different communities, of other different groups, and then forward the name. Now names will go to multiple places. It is not that they'll send it to Supreme Court. So this list will go to the state of UP, if it is from UP, or to the state government, to the governor, to the Home Ministry, to the Law Ministry, and to Supreme Court. 5 lists are prepared. Everybody has to give their input. So the government and the executive have their own state level, have their own intelligence input. Other inputs created, a dossier is made, it is sent. Same with the Home Ministry. They'll get an IV done, get everything, send his name. The person who's giving his name has to give his family background, has to give his financial status, has to give the details of the matters that he has been dealing with. The judges give their input, how good he is. So executive both at the state level and the center level are giving its input. So it is a misconception. It's an absolutely false notion that executive is out of this exercise. Executive has an active role to play in this exercise, and they give very serious report in these matters, and that report is taken seriously by the Supreme Court. So finally a dossier is made by the Law Ministry, which with regard to every person a dossier is made, the name would be there, the details of both the agencies, state and center would be there, the government's views would be there, everything would be there, and then it will go to the Supreme Court. Now the collegium there is it. The Supreme Court judges would sit over it, read every file, go through all the material, see whether there is any material in a support of anything negative or positive said about that person. If there is material is seriously considered. The names are then sent to the government. The old system was the government would thereafter clear the names and they would become judges. The new system with the new government, a majority government, which we are facing or we are seeing after quite a long time. India went through a system where there were no majority governments, there were coalition governments. So they are clearing some names, putting objections if they have any, sending the names back. If there is material with the objection, then it is taken into consideration. Number of matters, number of names which are sent back to the high courts for a second opinion. Number of names which are dropped if there is something serious. But number of names where the collegium feels, no, the person is being denied this opportunity because the government is not in favor of the person for certain reasons which has nothing to do with his being a judge. So there the collegium says, no, we are not satisfied with the objections you are raising. They are not relevant for his working as a judge and we are sending it again to you. Now if we give it absolutely to the executive, understand the difference between the two. If we give it absolutely to the executive, then we will give it to the IAS. Executive is the IAS. We cannot, because every day in a constitution, the first condition of filing a writ petition is it has to be against the state. If it is against the state, it is against the executive. 99% is against the executive. Hardly 1% is against the political power, role exercise, political institution. We will not surrender a power ever to the executive whom we are judging upon. Cannot be done. If you give it to the political head, then he will definitely, he is a trained politician, he may rather, I am not saying he will definitely, let's give benefit of doubt, but he may try to have people who are in line in his political philosophy. So then, after 10 years, 15 years, 20 years, you will have a tainted government, a tainted judiciary. We don't want a tainted judiciary also. So, what is being done is to find out a balance between the two institutions or the three institutions. Again, coming back to the same question, in a democracy, how different democratic institutions should exercise power and have a check and balance on each other. So this is a continuous process. We will never find one single definite answer. Be very sure of it. We will have some changes in the system. Again, after 20 years, when you people would be manning this institution, this question would still be there. In a democracy, how different institutions are going to have a check and balance amongst themselves. Our experience in the next 25 years will tell us what new changes are required in them. Neither you nor I can know what lies in future. But one thing we sure, changes do lie in future. Judiciary, judicial principles, way of working of the institutions is a ever-changing process. That is why we call our constitution a living constitution, a alive constitution, which will grow with time. It will come out with changes, or I call them, it will come out with improvements from time to time, so that the rights of people are protected. Those new rights which are required for better growth of people are created. Those rights which have become absolute with time are modified in a manner that better growth can be availed by people of this huge country. I think that answers your question.
Sir, I have a question.
Not a debate, a question.
So here, I have a question pertaining to Article 142. So it talks about complete justice. So, Supreme Court many a times through this Hercules technique have tried to do complete justice in the society. So don't you think Supreme Court itself touches the one of the basic feature of this doctrine, basic structure, that is separation of power?
Answer is both yes and no. Okay, so power of 142 is a very unique power. See, the constitutional courts more specifically are given a huge leverage in exercise of their power. Even the High Court judges have a power quite similar to Article 142. There is a threshold, there is a limit which we don't cross. Article 142 in positive word says that the Supreme Court can pass an order which is required in the interest of justice. They feel. Whether it is in accordance with law or not. There is another principle of law which we follow very strongly in High Court. That we will not issue a writ or direction which will create an illegal situation to stand and survive. So many times, we are faced with cases where an order is passed with this absolutely without any jurisdiction, without any power, without referring to any law, but which in the given circumstances is doing the right thing. I'll give you an example. So there's a political party which is in power. It asks its chief minister or its minister they want to use these services of the government. You direct your so-and-so department to give us these facilities. Take for example, there is a guest house. So this is a guest house which is having 100 rooms. We have a political party meet, so we'll occupy all the rooms, tell them to book them for us, and we'll not pay anything for them. So because it is on your directions, the room is booked, this is under your department, we'll use it, walk off, not pay anything. Now, that department dares to raise a bill. Or the government changes, new government comes and they say, let's raise a bill. And we'll recover it. We'll issue a recovery certificate. Now the party challenges it. No, you can't recover it from me. It's not the direction of the minister. I have nothing to do with it. I never said give me this hotel or this guest house. I never even asked for it. So ask for money from your minister, ask for money from your department, and do whatever you want. So what should the court do? And technically he is right. And technically he also says you can't recover this amount, there is no provision. So now it is for the court to do. Should it permit that recovery of the public money? Or should it interfere and say that no, there is no power in that? So then we apply ourselves and see what is right and how to do it. So though no such power is given to us, we are supposed to act in accordance with law. But what? There is another word used, in accordance with law and justice. So there are circumstances, very exceptional circumstances, where justice has to stand over and above law. 142 gives that to Supreme Court. In our own manner, we also exercise it, and it is repeatedly affirmed by the Supreme Court, again saying that yes, you will not pass an order which will create an illegal situation. So we have developed that principle, parallel to 142. So it has to be very circumvent situation to situation. Yes.
Good morning, Your Lordship. Woodrow Wilson, the former president of US, once remarked, the Congress in session is the Congress on public exhibition, while the Congress in committee rooms is the Congress on work. Now the universality of this statement can also draw that the Indian Parliament in session is the Parliament on public exhibition, while the Parliament in committee rooms is the Parliament at work. This brings to my question with respect to the demarcation of the definition of public basic structure doctrine. Why don't the Parliament of India send this issue to the parliamentary committee, or why don't the Parliament set up an expert committee for that? Thank you, sir.
So first, I don't agree with this statement. Parliament in session is not for public display. It is the Parliament in session which passes the bills. Every legislation comes from Parliament in session, not in committee rooms. They may frame a bill in committee room, they may have views in the committee room, but it is passed in the Parliament. So definitely the work is done in Parliament. Fine, they are also, while doing that work, addressing public at large, more so with now the direct relay being there. Again, should this principle of basic structure be sent to a committee and given it a definite shape, or should it be left fluid? We all are so anxious, especially the young generation, especially the young readers of law, that law should be definite and everybody should work as per law. This is okay for the normal law. But when you come to constitutional principles of law, they have to be fluid. Otherwise, if we make them straight jacket, you will become China. Because then you will not grow, or your constitution will not grow with changing times. It will not be able to adjust social media. Maybe it will refuse you social media. Because it is not as per law. Because no law permits social media, so you will not have social media. It is not provided in our constitution, you will not have it. So email is not provided, you will only write letters which will go through post and telegraph. So to give that flexibility, these principles have to be there. These power to interpret this principle should be both with the parliament and the government and the judiciary. Whenever they come on a loggerhead, they come in conflict. Why do we treat a case, more particularly a case with regard to interpretation of constitution, as a case between two conflicting sides? There is a huge difference when two individuals are fighting for their right to property in any manner, which most of the cases are, and cases with regard to interpretation of constitution law. A case with regard to interpretation of a constitution law is a dialogue between three democratic institutions: the executive, the parliament, legislature, and the judiciary. They all three are trying to find the best way forward for the people of this country. It is never a case understood in a normal way. It is never a conflict between three identities. It is an exercise by three identities to take country forward, to give best to the people of this country. If we understand it in that line, then we will see it in an entirely different perspective. And that is how masses have to understand it. The debates on TV are always motivated. The person who's sitting there is having a preconceived notion. A student of law can never have a preconceived notion. It applies to me as much as it applies to you. So please don't sit or don't develop this habit that this view is right and this view is wrong. The right way for today, it may not be a right way for tomorrow. The right way for today may be somewhere in between. And tomorrow, in which direction it will go, neither you know nor I know. So give it that scope to develop and grow with time. Give every thought scope to develop and grow with time. Decide it for today, it appears to be best for today. Take a step forward, leave rest for future. What results come, we'll look into it later. Golaknath to 72. This was the change. So don't fall in that debate. It is not a debate.
Last two questions.
Yes,
Big
fine.
and yes.
Good morning, sir. My name is Vidhi. Sir, since you mentioned about the institution of democracy, so we believe that election commission is one of the institute that ensures democracy. So with respect to the appointment of election commissioner bill 2023, has it been an ignorance on the part of the Supreme Court or a conscious choice to leave Article 324 out of the ambit of basic structure?
One more question from that. Take 2-3.
Very good morning, sir. First of all, thanks for this excellent discourse and this interactive session. Sir, I have a question not directly on the basic structure doctrine, but a facet of the basic structure doctrine. Sir, independence of judiciary is one of the cherished principles of the basic structure of the Indian Constitution, and much before Keshwanand Bharati also. Sir, there have been instances where judges retiring from the highest judicial offices have recently become part of the Rajya Sabha and other of public offices. And I think it's befitting to put this question to you since you represent judiciary.
I don't represent. I represent you.
Okay, sir.
I represent the people of the country.
So, what would be your opinion on post-retirement restriction, at least for 5 years? Because when judges retiring from highest offices join other public offices, it certainly takes away the faith of people of India, towards the judiciary of this country. What's your opinion in this regard, sir? Thank you.
So, first is with regard to the new bill with regard to the election commission. Nobody has, I don't think Supreme Court is named to have ignored any article of the Constitution or the basic structure theory. Why don't you take it as a new experiment for growth or with regard to better working of a democratic institution? Gain experience from it, and then if the experience is good, go with it. If it is not so good, again go for change of it, or declare it quash it at a later stage. Declare it invalid at a later stage, or modify or reread it to that extent at a later stage. So it appears to be, to me it appears to be more of an experiment at this stage. Let's see, there has been an election commission which was very dull initially, most ineffective. Came a period when election commissioners came and made that law very strong, effective. Again it appears to be dulling out a bit to some people. Again some changes being brought, being looked into. Let's see which way this goes. Right? Now coming to, sorry, can you just say it again?
Post-retirement.
Post-retirement. Precisely. Okay, so initially the age of retirement of High Court judges was 58 years, which was changed to 60 years. Now, judges should work after retirement or not? It's a very interesting question. It's a very serious question. And actually what work they are doing after retirement. So, with the improvement in the economic and other areas in this country, the longevity has increased. So you are much younger at 62 when you retire than you used to be 30, 40 years back. So you are able to put in a few more years in work. What has been done that meanwhile looking into the primarily, I believe so. One of the reasons that there is a huge load on judiciary, large number of tribunals were created. Instead of creating a proper system for manning those institutions, retired judges were taken and they were asked to work there. There's a very serious psychological problems with all us human beings. That if something is given to us for a short time on temporary basis, how so important it may be, we are not fully committed to it. If you are made a teacher in a college for 6 months, your interest in teaching or working of the institution would be very limited. Then you are a permanent teacher. Same goes with judges. We are also human beings, we are not falling from somewhere else. When we are asked to go to a tribunal for retirement from High Court is at 62 and retirement from tribunal normally is 65. 3 years. Some time would be wasted. 2, 3, 4, 6 months would take in the person going there, joining there, getting his appointment. So he was there for 2.5 years. So he is doing it with the sincerity that is expected from him. Some are good, some are okay, some are not interested. Fine. This has seriously impacted the working of the tribunals in this country. They are not effective. They are not as effective as they should. So definitely there are two questions which the government is facing, which the judiciary is facing, and again a dialogue is going on in the committee rooms, not in the open floor. The dialogue is that should there be an increase in age of judges, and then ask them to take a break, not bring them to the tribunals, to what should be the manner of manning these tribunals so that committed people who look a career in it, who look a future in it, would come and work here so that the tribunals would be more effective. The dialogue is going on. We are hopeful of a very good response or a new system coming out, and we are very positive. This is my personal feeling that after this election, if this government is repeated, then the PMO, to my understanding, to whatever podcasts and things I have heard from the people working in PMO is that the working of judiciary is one thing they want to address, so that this huge workload is done away with, so that we have a quick judicial system which is required for our economic growth also. Otherwise, the businessmen can't work here. There no business can survive if its dispute which is arising today would be decided after 10 years. The entire business would be gone by then. Second, what is expected to be the executive. The IS or the administrative service people are working as they were working in the British Union. There's a thought, I don't say they do it, there's a thought that they try to keep all powers to themselves and exercise it in the manner they feel is right. It is not their job. Their job is smooth movement of system, not obstructive system. Or to put it in other words, people feel that the license Raj from the government, from the politicians may have gone, but is stuck somewhere in the administration. So these are two fields which we expect to be improving in coming.